So I'm going to be talking about the legal battle for natural resources in Western Sahara at the European level and a little bit beyond European level as well. First of all, why do natural resources matter in Western Sahara, in the conflict in Western Sahara? I mean, there are many reasons. The main reason is obviously there are two principles of international law that matter in this regard. So the principle of sovereignty over natural resources and the principle of self-determination. And these two principles are very much linked. The socioeconomic development of a potential future state is what at stake here. And this link between these two principles have been, established at different levels. There's many General Assembly resolutions on the principle of sovereignty over natural resources. There's one in particular with regards to Namibia that the UN General Assembly passed in 1985, which state, I'm just going to give you the quote because it's very relevant for our discussion today. So it goes, any administering or occupying power that deprives the colonial peoples of the exercise of the legitimate rights over their natural resources or subordinates the rights and interests of those peoples to foreign economic and financial interests violates the solemn obligations it has assumed under the Charter of the UN. So this is very relevant for today's discussion. The International Law Commission as well in 2001 re-established this link, and recently in 2015 the African Union provided a legal opinion on the topic. So this is very much, what is at stake today. It's not only the sovereignty over the natural resources, but it's a question of expression of the right to self-determination. And obviously, you all know the legal opinion by Hans Korel of 2002, which was actually, he was asked by the Security Council, he was seized to answer the question of, what is an implication of exploring and exploiting natural resources in Western Sahara. So obviously, I'm not going to go into details about the conflict itself. I just assume that everyone has a broad knowledge of it. There's a few things that need to be still established. So, Western Sahara is a non-self-governing territory under the UN decolonization law, we should say. It is also an occupied territory, at least parts of it is occupied. So humanitarian law applies as well here. So the agreements that were tackled and challenged at the European Union level actually were contested because they supposedly didn't respect the right to self-determination. And we'll go into more details onto the content of these decisions. And it is important to talk about the exploitation and plunder of natural resources in Western Sahara, because it is linked automatically, winning these battles, the legal battles over this issue actually has an impact on the overall political process. So before I go into explaining more into details the decisions and how they came into be rendered, etc., there's a few things that we need to set on the background. So the main agreements that were tackled were one part, an agreement that was signed in 1996 but was only came into force in 2000, the Association Agreement, or the Euro-Mediterranean Agreement, which partly covered agricultural products originating in Morocco. At the time it was adopted, at the time it was entered into force, it wasn't, it didn't mention Western Sahara. It wasn't part of the agreement per se. The second agreement is the Fisheries Partnership Agreement, which was adopted in 2007. Expired a couple of times and it was renewed a couple of times. Same thing, it didn't mention Western Sahara, so it wasn't meant to be dealing with products or fishes from the waters adjacent to Western Sahara. What is interesting in the case of the Fisheries Agreement is that on one occasion, the agreement was not renewed because the European Parliament did not allow for its renewal and thought that it did not take sufficiently into account the interests of the Sahrawi people. Unfortunately, it ended up being renewed and it arrived at expiration in July 2018. That's when then just after the court decision that we're going to discuss, and that's when it was renegotiated, and then Western Sahara was included in its territorial scope. It's also important to note that the European Parliament has legal services, so any MEPs who wants to have an opinion on the adoption of an agreement can ask the legal services for their opinion. Which is interesting to note is that these opinions are not public. They are often made public, but there are several opinions that are interesting in the case of the agreements between Morocco and the EU in terms of natural resources. So there's 4 of them. Maybe we can talk about them later if if there's an appetite for it. But essentially, these opinions at different levels recognize that the waters adjacent to the territory of Western Sahara is not part of the exclusive economic zone of Morocco, and that the territory as well is not the territory of Morocco. So these opinions matter in terms of legal weight, if you want. So I'm just going to start by giving you the key outcomes of the 2 landmark decisions that I'm going to present. So the one from 2016 and the one from 2018, and then I'm going to try to explain the impact beyond on a couple of other decisions by the EU Court of Justice. And also a couple of other decisions that were rendered, one in South Africa and one in Panama, and then explain also a bit the impact on the relationship between the EU and Morocco. So for the first decision from December 2016, this was actually an appeal decision. In the first instance, the tribunal gave a decision in December 2015. In that instance, it was a case brought by Polisario against the association agreement, so covering the agricultural products. In this case, in the first instance, so the idea was that basically the agreement was violating international law, and in particular the principle of the right to self-determination of the Sahrawi people. So in the first instance, which is interesting, is that the tribunal actually granted standing to Polisario. So it thought and it declared that Polisario had a legal personality and had a direct and individual concern to challenge the agreement. And in that case, actually, the tribunal decided to ask for an annulment of the agreement. So it was a very big decision at the time. Obviously, the Council and the Commission appealed it. And a year later, we have the appeal decision from December 2016. And even though it didn't go as far as the decision on the first instance, it is still it still has a lot to provide. So first of all, the 4 main key conclusions that we have to remember are first of all are the fact that the territory of Western Sahara and the territory of Morocco are 2 separate and distinct territories. Second of all, that there is no sovereignty of Morocco over the territory of Western Sahara. Thirdly, the concept of the de facto administration, that is a concept that has been brought by the Commission and Council in this case, saying that, well, Morocco is de facto administrating the territory, so there is a reason for them to be dealing with products from Western Sahara. Well, this concept of de facto administration does not exist. This is not a thing. It would simply amount to occupying power, if you ask me. And then the last conclusion was that, and that is the key conclusion in this decision, is the fact that the consent of the Sahrawi people is required. So it's interesting to note that I'm not going to go into too much details regarding the legal aspects, etc., and legal argumentation. But so, as I said at the beginning, the idea was that the agreement was violating international law and the principle of right to self-determination. But in this case, the court didn't decide that, and didn't even examine the merits by addressing the issue of human rights and international law application to the trade agreement, because it simply declared that there is no territorial scope for the agreement. So basically, the agreement does not mention Western Sahara, so it does not apply to Western Sahara, which is a totally different territory. And so there is no need to discuss whether or not this, impacts the right to self-determination. So in a way, it was a way for the court to find, I think, a middle ground between the first instance decision, which was very, very much groundbreaking, and not acknowledging that the agreement was in violation of international law. So it is interesting that this decision is still quite, it's a landmark decision, and it has a lot to provide for future cases regarding Western Sahara at the EU level. And actually, in fact, the second decision we're discussing today, that of February 2018, actually pretty much largely takes up the same reasoning, and we'll go again and say that Western Sahara is not mentioned in the agreement, so there is no scope. It's not, we don't have to discuss whether or not it violates the right of the Sahrawi people. But it's interesting to note that in both decisions, the court has recalled that if Western Sahara was to be included in the agreement, this would then be in violation of international law. Mainly two principles. So the principle of the relative effect of treaties. So it's a principle of international law whereby, for example, if France is signing a trade agreement with Spain, this cannot cover product from Portugal, because obviously they're not part of the treaty. So the court, for the court, Western Sahara is a third party to Morocco and the EU, and if any of the products coming from the territory of Western Sahara were to be included, then they would need the consent of the Sahrawi people. So this is very important. What is interesting as well is that in both cases, the Advocate General was the same person, and he, in the first instance in 2016, pretty much summarized his argumentation, what was going to be actually the final decision. So for him, there was no question of application of international law, because the agreement doesn't apply to Western Sahara. In the case of the Fisheries Agreement in 2018, the same Advocate General actually asked for a complete annulment of the agreement. And actually, in his general opinion, I invite you to read it. It's very interesting. He actually employs the term occupation. So it is, the general opinion, Advocate General's opinion of 2018 is very, very groundbreaking. It has a lot to say about potential future cases at the EU level. So basically, these two different decisions bring a lot and a lot of information, and have had major impacts. A lot of people would say, for example, that the lack of standing of Polisario in the first case actually shows that Polisario doesn't have, they don't represent a state that exists. They have no legitimacy to exist, etc., etc. But this is interesting to note that the fact that they don't have standing doesn't tell us about who they are, the nature of who they are, but more on the nature of the agreements that they're trying to challenge. And that is really important, because the reason why they were saying that Polisario don't have standing is simply because the agreement don't apply to them, because they shouldn't apply to them. And if they did, that would be against international law. So this is a key point to remember from these decisions. In the case of the February 2018 ruling on the fisheries agreement, it was actually a case brought by Western Sahara Campaign UK in the UK court, and which was then transferred to the Court of Justice of the European Union through a mechanism that we call a preliminary ruling. So any matter of European law that is questioned at national level, then the judge can simply refer to it. So these two decisions are very, very important. They actually gave a lot of, they had an impact on all the decisions. There's another Court of Justice of the European Union decision from November 2018 on aviation this time. It's not natural resources, but it is very interesting nevertheless, because it again recalled the same principles and the same conclusions from the previous decisions on the distinct and separate territories, and the fact that Morocco has no sovereignty over Western Sahara, etc., etc. So this decision is also very interesting. Again, it recalled that if Western Sahara was to be included in the agreement, this would be against international law. So, as I said, against the principle of the relative effect of treaties, but also against the principle of self-determination, which is, by the way, a core principle of the UN Charter. So it's on its Article 1, and it's also on the common Article 1 for the covenants of on civil and political rights and socio-economic rights. It is a very fundamental right. The second decision that comes to mind is the decision by the Court of Justice from last November on Palestine this time, on the issue of labeling. So why I bring it up is because it's interesting to know that in this case, so the court decided that any product coming from the settlements in the occupied territories of Palestine have to be labeled as such. They cannot be labeled made in Israel. They have to be labeled made in settlements, made in occupied territory. And in its reasoning, the court actually mentioned the case on Western Sahara. So it's very interesting to know that it's, there is a jurisprudence on Western Sahara, and it is being used for other decisions. And it's very important to see, how what is the impact even within the EU law itself. So it used the jurisprudence of Western Sahara for its interpretation concerning proper and distinct status of a state which lacks sovereignty over another. So it's very important to note that these two decisions also had an impact elsewhere in Europe. The other impact that the decisions had were more political. Obviously, the decisions have an impact on the EU-Morocco relationships. And let's hope that the other way around will not be possible, that the EU-Morocco relationship will have an impact on the EU decisions. But there are different, after when I mentioned that the EU Parliament in 2011 denied renewal of the fisheries agreement, well, the next day, Morocco immediately asked European Union boats and ships to leave its territorial waters. So that again had a lot of, brought up a lot of discussion between Commission and Moroccan authorities. The same happened after the first instance decision in the association agreement case, when the tribunal decided actually that the agreement was contrary to international law and it should be annulled. In this case, then Rabat completely, cut their diplomatic relationship with, suspended at least the relations with Brussels. It's interesting to see, if you look at the statements and if you look at the press releases and if you look at different, media coverage at the time, every time there's a negative decision for Morocco, or I should say against Morocco, Morocco will always bring up the question of, this will impact our bilateral agreements with the EU, and by bilateral agreements they mean obviously everything that deals with immigration, tourism, etc., etc. So we've had a good presentation of this by Yahya Zubir recently, and it was very interesting to go into much more depth. There are a couple of other decisions that were rendered in different courts, one in South Africa and one in Panama. Both were rendered in 2017, so exactly in between the two decisions by the two main decisions by the European Court of Justice. And I think, in my opinion, it had impacted at least the opinion by the Advocate General, because it was the same Advocate General in the two cases, and in one he didn't ask for, or he didn't, didn't ask for invalidation of the agreements, and then second, after the 2017 decisions in South Africa, mainly in Panama, he then asked for, annulment of this agreement and talks about occupation, etc. So this, I think, it has had an impact on the 2018 decision. So the South Africa case was a case of a cargo, a cherry blossom, which was operated by a New Zealand company. So it was taking phosphate from Western Sahara down, back to New Zealand through South Africa. And upon its arrival, it actually was stopped and seized. And in this case, it was the Sahrawi Arabic Democratic Republic who challenged and acted, and for the first time acted in its capacity as a state. So it's very, very interesting. If the 2016 appeal decision and case by Polisario was the first time Polisario acted as a person, I mean legal person, the South Africa case was the first time that the Sahrawi Republic acted as a state, and it acted in its so in civil law, in its right to ownership over the phosphate that was being shipped and purchased. So in this case, it was a very, very strong decision. The court actually declared that Morocco has no sovereignty over Western Sahara again, and talked about occupation, and therefore that the phosphate seized belonged to the representative of the people of Western Sahara. So their UN, UN recognized representatives, Polisario. So actually the cargo remained for about a year, I think, docked in South Africa. I think at a fee of $10,000 to the owners, which ended up being quite a lot. So it was a real win for the Sahrawi Republic. And the second case in Panama, which was pretty much the same setup. So it was again a cargo that was arrested or seized. Its arrival at the Panama Canal. Again, the Sahrawi Republic acted as a state. In this case, it was less successful in terms of a legal decision. So the court didn't have the same conclusions as the South African court. And then the cargo went on to deliver its achievement. But it's interesting to note still that since then, there were no more deliveries through the Panama Canal of phosphate. And actually the number of companies operating in the transport of phosphate from Western Sahara has considerably decreased since that year. There's a very good report by Western Sahara Resource Watch that is being issued every year on the question of phosphate, P for plunder, and it's very insightful. I really recommend that you read it. The last one actually from February 2020 actually shows a lot of drastic decrease in the achievement and at least exploration of phosphate in Western Sahara. So I'm just going to conclude briefly because I think it's better to have questions and answers. But what happened since then? So after the decisions were given, obviously the Moroccan authorities, together with the European Commission and the Council, had to amend the agreement. Because in reality, even if the agreements didn't mention Western Sahara, products were still coming from Western Sahara. So there were still products, fish being brought into the European Union market from the waters next to the territory of Western Sahara. So it's actually in the documents from the Commission. If you read, if you go into the court decisions themselves with all the documents brought up by the parties, the Commission itself recognizes that up to, I think it was 91% of the fishes that were fished, the fishes that were brought up into the EU market actually came from Western Sahara. So even though the agreement didn't mention Western Sahara, there's still products coming from Western Sahara. So what the EU Commission did was engaged in a consultation process. So because the court had required that the consent of the Sahrawi people was collected, the EU Commission had to find a way to get that consent. But the only thing is the process that they engaged in was a consultation process, which is a total different thing from a consent. If I consult someone, if I can borrow their car, I'm not getting their consent. If they say yes or no, I'm just consulting them. So that's pretty much what the Commission did. And emailed a lot of different organizations throughout Europe, of solidarity groups with Sahrawi people, etc. Western Sahara Campaign UK was actually conducted for a meeting in Brussels. All the email correspondence is on the website, so you can all go and check it out. And obviously, you know, Western Sahara Campaign UK or even Western Sahara Resource Watch, these are not organizations meant to represent the Sahrawi people. So they are not, you know, they're not meant to be giving the consent on their behalf. Yet the Commission, after this process was done, mentioned Western Sahara Campaign UK, mentioned Western Sahara Resource Watch as, and many others, I think there was about 100, more or less 100 of them, as having been consulted. So that's now the basis for the next challenge. So Polisario has challenged that, the fact that the consent has not been collected properly. Before that challenge started, actually, there was a legal opinion from the European Parliament Legal Services, again, that was leaked a year ago, I think, and that said basically that the Commission's consultation process, they did not think that this process met the criteria set by the court in 2016, which is a big deal. This, you know, it was actually, there was that aspect, and there was also another aspect that decredibilized, in my eyes, and I think in a lot of people's eyes, this process, is that the European Parliament reporter on the file, Patricia Lalonde, was actually had to resign because of a major conflict of interest that she did not disclose. So basically, the woman who was dealing with the renegotiation of this agreement was sitting on the board of a think tank or lobby group in Brussels, mainly composed of, you know, former Moroccan ministers and other Moroccan public figures. So she had to resign about a month before the vote on the new agreement. Unfortunately, that was too late for its successor to really do anything significant with the file. So unfortunately, the new agreement passed in Parliament. So in January last year, for the association agreement for the agricultural products. And in February last year, the new fishing partnership agreement was also passed in Parliament. So, you know, as you know, I've met with a couple of MEPs and before the vote, and trying to explain to them, you know, that, you know, what would be the consequences. And a lot of them actually just, you know, thought that it didn't matter if the agreement was not agreed now, or if it was, because at the end of the day, they were just trying to gain time. I was really sad to hear, but it is what it is, and now there's a new challenge, and this consultation process will be challenged and addressed, and hopefully we'll have a hearing soon. But again, in my view, the legal battle is the battle that the, you know, Sahrawi people is the most likely to win, because the law is clear. The principles are set. They cannot be, you know, this decision cannot be undone. So I don't see how how the court can again try to bypass the law. It's interesting, like, you know, there's one specific paragraph of the 2016 decision that actually says, you know, the consent is required, and it doesn't matter. Well, it doesn't say it in this words, but it doesn't matter if the agreements benefit to the people. what is necessary is the consent. So, and this game that the Commission has played to say, oh, but it's benefiting the local population, and etc., etc. In my view, is not going to work. We'll see. I can't speak on behalf of the judges, but I think at the end of the day, this will come around, and hopefully soon we'll have a strong decision that will actually follow the Advocate General's opinion of 2018. I'll just stop here for now. I'm sure there will be questions. So